Hello everyone and welcome back to our channel. My name is Anda Malescu and I am the owner of Malescu Law, a law firm based in Miami, Florida, specializing in business, corporate and US immigration. We can assist you with all your immigration needs regardless of where you are currently located or where you plan to go in the United States. Today we are going to speak about the pros and cons of obtaining your green card through adjustment of status versus consular processing. However, it is important to keep in mind that the adjustment of status is only available to certain individuals, those that are physically present in the United States and typically must maintain valid status, with very small exception for family-based category and employment-based category. However, before you even consider the adjustment of status application, you should consult with your immigration attorney to see if you qualify for the adjustment of status in the first place. Now, before we get started, please subscribe to our channel by clicking the bell button or the subscribe button. As I already discussed, choosing between obtaining your green card through adjustment of status or through consular processing depends on your individual circumstance. However, there are certain factors you need to consider, and these include: 1. Current location. With the adjustment of status application, you need to be physically present in the United States at the time of filing the adjustment of status application. And you must have entered legally the United States, and you must generally be in valid status in the United States at the time of filing, with small exceptions for certain family-based categories and employment-based categories. And with the consular processing, you can apply to obtain your green card through consular processing from within the United States or outside of the United States, and basically your application will be sent to the US consulate in the country of citizenship or in the country of residence, and you will have to travel to that specific US consulate in order to have an interview and obtain your immigrant visa there. Travel. This is 2. Travel. With the adjustment of status application, you typically can apply for a travel document, also known as Advance Parole document. You can apply concurrently with the filing for adjustment of status application, or you can apply separately after you have filed your adjustment of status application. It is important to understand that if you travel outside of the United States while your adjustment of status application is pending and you do not have an approved travel document, the advance parole document that we discussed, then your application for adjustment of status will be denied for abandonment. So it is important that once you have filed an adjustment of status application, in order to travel internationally, you obtain an approved travel document from the United States Citizenship and Immigration Services that will allow you to travel outside of the United States and possibly to come back in the United States. Now, an approved advance parole document, the travel document that I am talking about, does not guarantee that United States Customs and Border Protection Officer, a CBP officer, will allow you to come back in the country. So just because you have this advance parole document approved does not necessarily mean that at the border, upon your return to the United States, a CBP officer will actually admit you back into the United States. Travel with consular processing. So if you have an application to obtain your green card through consular processing, then you do not need to obtain an advance parole document, the travel document that we spoke about. This does not apply to you. And generally, while your consular application is pending at the US consulate, you are permitted to travel in and out of the United States as you wish. But at times it is not recommended. So it is important that you check with your attorney to see whether or not you should be traveling to the United States while your consular application is pending at the US consulate. 3. Work permit. With the adjustment of status application, you can apply for a work permit, also known as an EAD card, on Form I-765 with the United States Citizenship and Immigration Services. Now, you can apply for the work permit concurrently when you file your adjustment of status application or after you have filed your adjustment of status application. If approved, the work permit will allow you to start working in the United States while your adjustment of status application is pending. Keep in mind that the average time to obtain a work permit is around 3 months, but the processing times constantly change. Now, if you are applying to obtain your permanent residence through consular processing, then you cannot apply for a work permit. Okay, so the work permit, obtaining an EAD card does not apply to you if you are obtaining your green card through consular processing. 4. Interview waiver. With the adjustment of status application, the United States Citizenship and Immigration Services has the discretion to waive the interview requirement for the adjustment of status applications. Generally, interviews are waived for employment-based categories and in certain cases for the family-based categories, but this is strictly in the discretion of the United States Citizenship and Immigration Services. If indeed your interview is waived, then you do not need to attend an in-person interview for your adjustment of status application at one of the United States Citizenship and Immigration Services offices, and instead USCIS will approve the application and mail the green card to your address. Now, in the case of consular processing, you do not have the option to waive the interview requirement. Consulates do not waive the interview requirement for your permanent residence. So you will be required to attend an in-person interview at the U.S. consulate where your application for immigrant visa is pending. 5. Processing times. With the adjustment of status applications, you can expect much longer processing times when you compare it with the consular processing. So sometimes you have to take into consideration the time it will take for you to actually be able to obtain either your immigrant visa through the consular processing or have the adjustment of status application adjudicated. But in general, expect that at the United States Citizenship and Immigration Services, the processing times are longer when you compare it with the U.S. consulates abroad. Now, for those immigrant categories with the adjustment of status with immigrant categories in the EB1 category, employment-based category, and immediate relatives of U.S. citizens, the processing times are anywhere from 6 to 12 months. But for the other categories, the processing times can be longer. So if you want to speed up the process, it is sometimes better to consular process your permanent residence and travel abroad and have the interview, obtain the immigrant visa, and then come back into the United States and be admitted as a permanent resident. Premium processing. Premium processing is not available for both the adjustment of status applications with USCIS or the consular applications with the U.S. consulates abroad. In the case of consular processing, you may be able in very limited circumstances to obtain expedited processing, but that is typically only in cases of urgent medical emergency situations or when dependent children are approaching the age of 21 and risk aging out of eligibility. So while you do not have premium processing available with the adjustment of status application or consular processing applications, you may be able to obtain expedited services with consular processing, but again, it will be in very limited circumstances. 7. Eligibility. Both the adjustment of status and consular processing applications have very specific eligibility requirements that depend on the immigrant category you're applying under and your situation. And finally, 8, cost. The adjustment of status applications are more expensive than the consular processing application, and that is due to the additional USCIS fees that you need to pay. So keep in mind the adjustment is more expensive than the consular processing. This is all for today. Thank you so much for watching. Please subscribe to our channel, and if you need to get in touch with us, you have our contact information in this video and below this video. We will see you soon. Bye.